Have you ever heard an attorney making a request for a mistrial during the course of a trial in New York? Would you like to learn what happens and why an attorney would make that? Come join me. I'll tell you exactly why. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. A request for a mistrial is a serious request. Why? Because one of the attorneys is now asking the court to say, Judge, stop the trial, throw everything out that we've done so far, whether it's been days that we've taken trial testimony or even weeks. Something has happened that is so prejudicial that it's going to affect the outcome of my particular case. And now the judge is going to have to decide whether or not what the attorney is asking is appropriate. Now, here's why an attorney would be making a request for a mistrial during the course of trial. A witness may have said something that so taints the jury. That means that the jury is now so prejudiced because of something they heard or something the attorney did or maybe something the witness did. And now that there's no way to recover from that incident. And as a result, the attorney believes that the only way we can possibly resolve this is to declare a mistrial, throw the entire proceedings out for the moment, and then start the case all over again from scratch at a later time. Now, to do that, the judge has to recognize that doing so would be an entire waste of all the resources of the court, all the time and effort and energy that all the parties put into the case, all the witnesses, all the money, all the expense put in to preparing for the case will all be thrown out the window. And that's a very significant thing to request, and it's something very significant for the judge to consider. Now, another time that there might be a mistrial is during jury deliberations. If for some reason the jury cannot reach a conclusion, they cannot come to a decision based upon the information they have in front of them, and now they're deadlocked, they cannot reach a decision. In that instance, the judge may have no choice but to declare a mistrial if the jury comes back and they are deadlocked and cannot reach a decision. So those are the two real main reasons why a judge would consider a request for a mistrial. So why do I even tell you about this? I tell you about this because chances are you watch TV, you learn in the news about cases that are going on, that are happening in the news, and you may learn about different mistrials that occur or attorneys who have requested mistrials during the course of or at the end during deliberations. And chances are you have questions and concerns about your particular matter, and if your matter happened in the state of New York, what I encourage you to do is pick up the phone and call me. I answer questions like yours every single day. And you can reach me at 516-487-8207 or by email at lawmed10@yahoo.com. I'm Gerry Oginski here in New York. Thanks for watching.